Bobette Swallen against Satterswaite and others.
Mr. Mitchell.
Good morning, Lord. May it please you, Lords, as the newest kid on the block in this litigation, can I introduce my learned friends? I appear for the appellant together with my learned friend, Mrs. Caroline Hay, Queen's Counsel, who has appeared in every stage of this litigation bar the original application. And in the original application, learned friend Mr. Nigel Park appeared, who sits at the end of the row. So there's a long background of assistance available to the court. So far as the respondents are concerned, learned friend Mr. Terence Williams, who represents the first respondent in the criminal litigation, appears therefore on her behalf together with Mr. Isat Buchanan, who sits immediately next to me. Learned friend Mr. Ian Wilkinson, Queen's Counsel, who is one in from the end, represents the second and third respondents, Janet Ramsey and Paulette Higgins, together with learned friend Mr. Lenroy Stewart, who is next to him, and learned friend Ms. Cadine Hilton, who is immediately behind him. Lord, this is an appeal by special leave against the decision of the Court of Appeal of Jamaica, setting aside the first instance decision of Mrs. Justice Shaw in part, and the part that is the matter of review before this court is the permission to review documents that were uplifted during a search and seizure warrant as far back as 2013 that related to documents connecting the first, second, and third respondents together with a man by the name of Andrew Hamilton, who was a convicted drug trafficker, and I'll come back to that in a moment.
Yes, Mr. Mitchell, you can take it that the board will have read the judgments of the courts below,
of course, Lord,
and the parties' cases.
So I'm going to be quite. I'm going to take the introduction fairly shortly, my Lord, and I'll make it even shorter than that.
For that reason, you may.
Can I just a little bit of housekeeping to assist the court? First of all, electronic page 405. Our case is wrong at the end of paragraph 11 when it says that the warrant that was executed in relation to the first respondent is not in the bundle. It is, and it's in the electronic bundle at page 183. I think that where we fell into error was that it wasn't separated out, and what had been separated out was the warrant that was executed against the second and third respondents' homes. But the main search and seizure warrant is indeed in the bundle at electronic page 183. Lord, having indicated, of course, as I would expect, the court's read all the papers, I'm just going, if I may, to refer to some important page numbers.
Of course.
The affidavit in support of the original order begins in the electronic bundle at page 153.
You're not to assume we've read documents like that. The documents we have read are the ones I mentioned.
Of course. And I, Lord, I'm just going to give you references, if I may, unless I need to delve in detail into the evidence.
Thank you.
The important part of this affidavit, which is the affidavit that was filed for the original search and seizure warrant, is that it sets out the detail of the relationship between the first respondent, an attorney, and Andrew Hamilton, the brother of respondents 2 and 3, who is also a convicted drug trafficker. Now, on that score, I just pick up something of my learned friend Mr. Wilkinson's submissions, because if your lordships would go, please, in the electronic bundle to page 433, your lordships will see that my learned friend speaks of the reference to paragraph 20, to Andrew Hamilton's convictions in the record of appeal, speaks to Andrew Hamilton as having 2 convictions of drug-related offences, of emphasis supplied. However, later references to these convictions, including in the appellant's written case, have morphed into drug dealing or drug trafficking. My learned friend then goes on to say, in our humble opinion, drug-related offences are not the same thing as drug dealing, and knowing that your lordship ought to have read it, I don't need to continue, but his criticism is plain. But if my lords would just make a note in the electronic bundle at pages 154, 157, and 158, in the affidavit in support of the application for the search and seizure warrant, the applicant sets out in considerable detail the offences, the background, and the nature of the convictions. And that criticism, therefore, of my learned friend doesn't stand the test of the evidence. Can I similarly, because I'll come to it, but whilst we're at electronic bundle page 433, my learned friend goes on at paragraph 22, further equally unfortunate or unpardonable are the contents of paragraphs 9 and 10 of the appellant's written case, which refer to evidence which have been adduced in the above-mentioned part-heard trial during the prosecution's unfinished case. More particularly, the information in paragraphs 9 and 10 is not in the record of appeal, was not before the JMCA when the appeal below was being heard, and further prosecution is yet to close its case in the trial, and the trial judge has not ruled that the accused have any case to answer, and the judge hasn't pronounced on the effect or relevance of the evidence. Lord, when we refer in our written case, page 405, to, and it is important, 9 conveyancing transactions taking place before the 30th of May 2007, which will a date become oft mentioned during the appeal and is a date that we will focus on, have given evidence without objection. We took that from the statement of facts and issues. So my learned friend's criticism in paragraph 22 doesn't sit with his agreement as a signatory to the statement of facts and issues, which itself references the fact that 9 of the conveyances took place before the 30th of May. It's important also in the context of this appeal to pick up on 2 other points which are sought to be argued by my learned friends. One is what I might term the LPP claim. Lords, we weren't graced with any respondent's notice from the first respondent. So the first we saw of this was, of course, in the respondent's case, the first respondent's case. It is right to say that to examine that LPP claim is difficult in this context. One, all the material seized in December 2013 is still under seal and has and remains so. So there's no opportunity to examine the documents themselves. They remain under seal because at the time they were seized in the presence of independent counsel, the first respondent raised the issue of LPP and everything was then sealed. And indeed, it was the hearing before Mrs. Justice Straw that led to, I've done that twice now, as my learned friends remind me, the reference to the application before Mrs. Justice Straw was an application to set out the terms and circumstances by which the material could be examined. That was then appealed. And as your lordships know, the appeal was allowed only to the extent, and we see this as the heart and soul of this appeal, that the material that was uplifted that referred to transactions before the 30th of May 2007, that important date, the date when the Proceeds of Crime Act in Jamaica came into force, had to be returned. And it's the appellant's case that when the Court of Appeal rejected the submissions which have been highlighted and referenced to as referable to the Petman principle, but I think it goes wider than that, on the basis that, and as my lord will remember, paragraph 86 of the Court of Appeal's reasoning, that even if the evidence is incomprehensible without it, it must still be returned. And I think, lords, that I should take your lordships to that paragraph in the judgment of the Court of Appeal at page 274 of the electronic bundle, so that we can just have a look at that for a moment. What the Court of Appeal did, and my lords, this raises an issue as to how the court is going to deal with some of the points that my learned friends have raised. And that's not just the LPP point, which I started with, but also the constitutional argument, which my learned friend Mr. Williams seeks to raise, is that the Court of Appeal dealt with LPP at some length, constitutional, I accept, very short shrift, but they were dealt with. I haven't seen any respondent's notice. I repeat that because we're concerned that the appeal goes off at a tangent which it shouldn't. But going back to this narrow issue, paragraph 86, in conclusion, in my opinion, being cognizant of the interplay of the provisions of POCA and the Interpretation Act, there is no doubt that the court could examine any alleged criminal behaviour activities which could lead to an inference of money laundering having occurred. Well, obviously, we agree with that. Additionally, there's no requirement to prove a prior conviction or any specific connection with criminal property in order to ground examination of the document seized. Again, we agree with that. But this is where we respectfully submit the court fell into error. However, to be relevant under POCA, I don't know where that's coming from.
If someone has a phone on, please switch it off immediately.
Thank you. However, to be relevant under POCA, the alleged criminal activities must have occurred after the 30th of May 2007. Otherwise, they cannot be considered criminal conduct generating criminal property. That would also refer to and include background information if occurring prior to the appointed date of the 30th of May, even though it could be said that the evidence was incomprehensible without it. And with regard to this case, therefore, the properties purchased before the 30th of May 2007 and the transactions occurring before that date, and as indicated, any allegations of criminal behaviour activity are irrelevant to the application before the court and ought to be returned to the appellant interveners forthwith. In my opinion, these offences and or investigations would have to be pursued under the repealed Money Laundering Act, as sections 25, 2D and E of the Interpretation Act preserve that process. Now, can I deal with that in this way? I don't believe there's any dispute, although I think in Mr. Wilkinson's case he tries to argue this, and if I have got the wrong respondent, forgive me. But in our respectful submission, I don't think there's any dispute that offences up to the 29th of May 2007 that are money laundering could be prosecuted under the Money Laundering Act as repealed. The Interpretation Act preserves that. There's nothing unusual about that, and that plainly is the position. Similarly, any offences committed on or after the 30th of May could not be prosecuted under the Money Laundering Act, but could be prosecuted under the Proceeds of Crime Act. The issue for your lordships to determine in this appeal is whether, where you have an ongoing relationship, a relationship that has been built up over a number of years between a number of people and that the relationship continues on and after the 30th of May, which, on the Crown's case, becomes a criminal relationship on or after the 30th of May, the investigators, and please, I emphasize this is an investigative search and seizure warrant, are the investigators to be denied access to material before the 30th of May that would inform that relationship. And we would submit that all the authorities, however one analyzes them, would come down in favor of the material being relevant, available, important for the purposes of the investigation.
Mr. Mitchell,
Lord.
assuming all those three descriptions applied to a document, would that be enough to ensure that the document was not subject to privilege?
Lord, the issue of privilege...
My perception is that the test for that might be a little tougher.
My respectful answer to the issue relating to privilege is that is so well covered in the affidavit of the officer at the first application. My lords have indicated you may not have yet delved in detail, and I've only given you paragraph numbers, but it's eye-watering, to say the least, to see what the relationship was, even to the extent that the first respondent had what was described as a client account with the defendant, the drug trafficking defendant, Andrew Hamilton's sister, daughter, into which cash was deposited and from which money was taken to buy properties. In addition, the first respondent was the witness to conveyancing transactions of people who were fictitious, didn't exist, or if they existed, they weren't in Jamaica at the time when the transaction took place. So I won't resile from the expression eye-watering as a way to describe the relationship between attorney Mr. Hamilton and his family. And therefore, the issue of LPP, which my Lord Briggs raises, examined as it was quite carefully, as you will have seen in the Court of Appeal, and indeed by Mrs. Justice Straw, it's clear that all the judiciary to date have been perfectly satisfied that however high you put that test, at this stage of the investigation, that there is more than ample material which justifies the seizure of those files. I add to that, of course, in the context of LPP, we are dealing with conveyancing files, which your Lordship may consider has a slightly less relevance to the issue of LPP in terms of litigation and advice privilege. I accept, of course, that there may be advice emails or advice notes within a conveyancing file, but the conveyancing file itself containing the transaction would not be covered. We would respectfully submit by legal professional privilege in any event. And on the basis of the affidavit of the appellant, which I think it's important to emphasize, though I appreciate that the criminal trial continues, has never been answered. So we are in a position where the litigation in relation to this search and seizure warrant has seen an application to set it aside, which has been dismissed, and an appeal in that regard has been dismissed. An application by the state to examine the material has been accepted at first instance and only narrowed on appeal in respect of pre the 30th of May. The issue of LPP has been examined quite carefully at all those stages, and no one has questioned that the right of the state, the Crown, to have access to that material. In addition, though I make the point in the context of having emphasized that the trial continues, of course, the first respondent second and third respondents have not put in evidence in the context of this litigation to rebut the position taken by the appellant. And so that stands since 2013 as the evidence.
But I thought the Court of Appeal reasoning was to allow the appeal to the extent they did because legal professional privilege, as far as they saw it, extended in relation to material where all it was showing were criminal activities prior to the 30th of May 2007. I thought it rested on legal professional privilege.
I must say, my Lord, that I, having gone straight to the conclusion, drew out of the Court of Appeal's reasoning, whatever may have been subsidiary reasons, the 30th of May was the reason why the material was not to be noted and examined. And that, with all due respect to my Lord, the LPP would be a hook to hang it on, because if my Lord's view of the reasoning is right, well, then it should apply post the 30th of May as well. It doesn't, unless somehow the reasoning is, well, since it isn't criminal activity up to the 30th of May per the Proceeds of Crime Act, therefore it's protected by legal professional privilege, therefore it needs to be returned. I mean, that argument, we would respectfully submit, well, that reasoning is unsustainable in the sense that the conduct between the attorney and her clients is conduct which continues on and after the 30th of May and therefore is capable of being reviewed. And any defense that says, well, it's privileged before the 30th of May doesn't sustain the test if it is seen in the context of the criminal activity on or after the 30th of May. Because there are a number of...
What is the test that we're being asked to apply for legal professional privilege? Is it that we're talking about evidence of criminal conduct, or is it a wider test to do with evidence that may be relevant in understanding the background to what has gone on?
Without conceding the use of the word wider, it is undoubtedly evidence that is relevant to proving and sustaining a relationship between the first respondent, Hamilton, and his sisters. And not only relevant, but highly relevant. And can I illustrate it in this way? On or after the 30th of May, you might expect that an attorney who had been dealing in an area of work, transactional work, that certainly would have raised, and indeed the Court of Appeal recognised this, issues of criminality under the Money Laundering Act in any event. So my Lord's point about, well, it wasn't unlawful before the 30th of May, perhaps needs to be looked at in the context of the Money Laundering Act. But if everything was in the minds of the attorney acceptable on the 29th of May, but on the 30th of May, because of the Proceeds of Crime Act, it became criminalised, the same relationship, you might expect that realisation to be marked by a due diligence review. You might expect a file note that indicates something that has happened because of the commencement of legislation. And the only way that you can understand all of that, and a court could understand all of that, is by seeing and noting the context of the relationship. And I go one stage further. If the Court of Appeal are right that it doesn't raise unlawful or criminal conduct, then, of course, all the authorities which are relied on by my learned friends about proving other criminality, and you've got to try and strike the balance between the interests of the trial and the prejudice that may fall to a defendant by other criminal activity being led. If it isn't criminal activity, well, then that risk of prejudice doesn't arise. If it's relevant and probative to the issues in the case on or after the 30th of May, and your lordships may think that property bought in 2006, 2007, before the 30th of May, material that is transacted after that occasion, all becomes part of the mix of the material that is going before the court. It is very difficult to segregate it by reference to a date plucked out by Parliament for the commencement of a piece of legislation, because that doesn't dictate the whole relationship that was going on. And perhaps I can do no better than take your lordships, please, to page 788 in the bundle, in a case which we say, by parity of reasoning, is of real relevance and importance to your lordships in this appeal. It's an extradition case. Yeah. So the mindset may be, well, what's the relevance of that to this? But here's what happened. The defendant was extradited from Sweden. Your lordships will find this beginning at 788. The count against him spanned conduct which had taken place between 2002 and 2010. The Swedish court ordered the defendant's extradition in accordance with the warrant, with the exception of the acts which had taken place prior to May 2007, since prosecution in respect of such acts was statute barred under the Swedish 10-year limitation rule. And so, statutorily, in Sweden, the defendant could only be prosecuted for offences after the 1st of May. Or I say the 1st of May, after May 2007. I don't think that during the appeal we ever got down to the precise date in May. And so if we can turn against that background to paragraph 15, the matter came before the Vaxio District Court in Sweden in May 2017, and they granted the surrender for the prosecution, with the exception of the acts that have taken place prior to May 2007. The acts which the defendant is alleged to have committed would be characterized in Swedish law as gross bribery, or the gross giving of bribes. From the European arrest warrant, together with the additional information supplied, it's clearly evident that the defendant was suspected of passive bribery involving the payments that occurred during 2007-2010. If I may go on, and we do rely quite heavily on this, because by parity of reasoning we submit that you get some help from the Court of Appeal in England about how to apply this statute bar, or this line in the sand. As the district court has understood the arrest warrant, it now cites that the alleged acts only concern payments that have occurred after May 2007.
I'm so sorry, which page are you on?
I'm on 791, Lord.
Thank you.
Forgive me. According to the district court, the acts in the arrest warrant are considered to correspond to the giving of bribes in accordance with Swedish law. Against the background of the circumstances that are stated in the arrest warrant, and primarily with consideration of the significant sum that is alleged to have been paid, the district court considers the acts to be a gross crime. Swedish law and limitation thereby do not constitute an obstacle for surrender to the warrant. And then at paragraph 18, Lords, on the next page, 792, on the 31st of August 2017, the SFO's file note recorded a discussion with the Swedish DPP, who handled the extradition. Mr. Andrews was very clear on the telephone that the defendant's extradition was only in respect of conduct post-May 2007. Certain irony, as Mr. Wilkinson in his written case points out, of the year and the month. He commented that in Sweden, the evidence of the conduct prior to May 2007 would be admissible as important background as it contextualizes why the defendant did post-May 2007 what he did. In a subsequent letter, paragraph 19, dated the 13th of September 2017 from the SFO to the defendant's solicitors, having considered the judgment further, we accept that the Swedish court authorized extradition only in respect of your client's conduct from May 2007. Given that your client is charged with conspiracy, nor a difference, because in this case the defendant is charged with a significant number of substantives, but it still amounts, we submit, to the same thing. It's an examination of, in this case, the respondent's conduct. It is our view that the jury can convict him on the basis of his acts in furtherance of the conspiracy from May 2007. However, this does not prevent the prosecution from adducing evidence of his acts prior to that date as self-explanatory evidence of his later acts. We also accept that the judge should be invited in the event of a conviction only to sentence him for his acts from May 2007. The chief prosecutor responded from Sweden to a question from the SFO saying, concerning your specific question, the statute of limitation does not prevent a prosecutor from submitting information as evidence that concerns facts or events that occurred under a period of time that has been statute barred in light of the particular offence in question. What is statute barred is the offence, and we so heavily rely on this. What is statute barred is the offence, not the evidence that may be relevant for the understanding of another offence. Using your words, the prosecution can adduce evidence of what the defendant said or did before May 2007 to prove that after that period he was still acting in furtherance of the said pre-existing conspiracy. In his ruling, this is now the Court of Appeal referring to the first instance decision. In his impressive ruling, the judge spoke of sustained conspiracy to corrupt, in which, on the evidence, the defendant had played a major role. Although the defendant was a citizen of Sweden for the most part to conduct his activities there or in Lithuania, the judge observed that a substantial of the measure of the activities of the conspiracy occurred within this jurisdiction, at least prior to May 2007. One of the other defendants had pleaded guilty to a count similar to that on which the defendant had been arraigned. Another one had pleaded not guilty and was tried, but the jury couldn't agree, and his retrial has been fixed, and a joint trial is contended for. Supplementary material furnished paragraph 24 by the SFO to the Swedish authorities set out in detail clear evidence of the defendant's continuing participation in the conspiracy within the period 2007-2010, and shows that the participation reflects discussions and arrangements by the defendant and others, including NR, made before that opening date, and with others, including JV, now contracted to both APL and APS, but continuing to be resident in the UK and operational at their Derby offices after that date. And the judge concluded this, and Lord, this background is important for what is to come, we submit. The judge had said at first instance, were I to decide on the specialty argument that the defendant could only be tried on an indictment limiting the conspiracy to the period May 2007 to March 2010, that the evidence of all that had gone before would, subject to any specific arguments as to the admissibility of individual parts of it, and plainly we concede that, be admissible as relevant evidence showing a course of conduct by the defendant in the furtherance of the agreement existing with the 2007 to 2010 period. That not only accords with Swedish law, as just recited, but it is, of course, consistent with English law. And the parity of reasoning argument becomes, we submit, clear and plain. Even were the Court of Appeal, say, the judge to have accepted that the Swedish court had made its decision in the belief that no evidence outside the limitation period would be relied on, that cannot intrude on relevant rules of evidence and admissibility of the court, which subsequently comes to try the person extradited. And then, if we could go, please, to the court's discussion, beginning at paragraph 43, which, my lord, is at 797. Pulling the threads together, we are satisfied that the following propositions are well-founded in principle, apparent from the language of the 2003 Extradition Act and clearly established by authority. And what we submit is that your lordships benefit significantly from this. The specialty rule is concerned with offences. The Proceeds of Crime Act is concerned with offences, not evidence. Thus, the rule operates to prevent the requesting state from dealing with the defendant from an offence different in its essential nature from the charges upon which he was extradited. Thus, the Proceeds of Crime Act operates to prevent a court from dealing with a defendant for an offence committed before the 30th of May 2007. Provided the offences tried comply with the rule, provided the offences tried comply with the statute, the prosecution is not limited by the specialty rule, the statute, with regard to the evidence or additional evidence it is entitled to adduce to establish the defendant's guilt. 2, Roman 2, this conclusion as to the focus of the specialty rule is consistent with its origins and rationale in international law. This conclusion as to the focus of the commencement date of legislation is consistent with the legislation itself, respecting the power of the requested state to refuse extradition and ensuring that that power is not circumvented. Your lordships, I hope, can see how the parallels are running through this submission. Questions of evidence and procedure are for the courts of the requesting state, as are fair trial protections. All such matters fall outside the specialty rule and for the courts of the requesting state, not the courts of the requested state. Questions of evidence and procedure are for the trial court, as are fair trial protections. All such matters, you may think, fall outside, we would submit, the issue of the grant of an investigative search and seizure warrant, and are for the courts of trial to determine, not the judge at the time the application is made, provided the various access conditions of the Proceeds of Crime Act in relation to the warrant have been satisfied. Those, obviously, being in the public interest. When you've read the affidavit, which I won't waste the court's time going through because I've summarized it, you will recognize the importance of the public interest and the significant value that that would bring to a prosecution of an attorney and the other respondents in the context of this case. And then, therefore, moving to conclusions. In the light of the conclusions to which we have come on the principle of specialty, the statutory language and the relevant authorities, we have no hesitation in concluding that the application is doomed to fail. And this is our submission. The essential fallacy lies in the misplaced focus on evidence, whereas the specialty rule is concerned with the offences in question. The authorities are not distinguishable merely because the offence with which the defendant is charged involves a course of conduct. There is no arguable case that the SFO's reliance on evidence predating May 2007 to assist in establishing the defendant's guilt on a charge of participating in a conspiracy post-dating May 2007 infringes the specialty rule. A telling example is the inhibition, if the defendant's case was well-founded, on the SFO's ability to narrate the history of events, including the linkage between the promise of bribes and their later payment in accordance with an agreed timetable. That would be a striking constraint and a novel rule to which we would not accede unless driven to do so. It would still be more startling. I think it would be still more startling, as opposed to still be. It would be still more startling in the present case, given that there is no such exclusionary rule in Swedish law, and there is no such exclusionary rule, we submit, in the common law for the exclusion of evidence that may inform and narrate a history because it wasn't contrary to law when that history was being developed. And so it goes on. There's the ability to narrate the history of events, including links between promise of bribe and a later payment in accordance with the timetable. That would be a striking constraint, novel rule, to which we would not accede unless driven to so. It would be still more startling in the present case, no exclusionary law in Sweden. We are wholly unpersuaded the SFO's approach to the evidence is inconsistent with the manner in which the matter was presented to or dealt with by the Swedish authorities and Swedish court. This court takes the United Kingdom's international obligations seriously, but there's no arguable case the SFO's stance on this issue fails to honour those obligations. To repeat, offences form the subject matter of the specialty rule. To repeat, offences form the subject matter of the litigation, prosecution under the Proceeds of Crime Act, and go to the courts. I'm going to interpret the words consistent with our case, go to the court's obligations. The focus on offences furnishes the specialty protection. The focus on offences furnishes the legislative protection to which the defendant is entitled. He has enjoyed the benefit of that protection. He will enjoy that benefit. She will enjoy it. Matters of evidence fall outside that rule, the specialty rule. Indeed, they are for the courts in the requesting state, not the courts in the requested state. For completeness and for the avoidance of doubt, whether particular items of evidence are admissible or not will be a matter for the trial judge, as will be all questions going to the fairness of the trial. The judge's ruling on this issue was plainly correct, and the defendant's application for leave to appeal must be refused.
The problem I have with that is that it is dealing in general with the admissibility of evidence. I thought the problem we had here was about legal professional privilege. This is a general statement about admissibility of evidence dealing with a situation where you've got offences only being charged after a certain date. And it stands as helpful evidence of that. But the problem I want you to drill down on to help me is, as I understand it, the rule that we're dealing with in relation to legal professional privilege is the exceptional rule that would allow evidence in relation to direct evidence of criminal conduct. That is the exception that we're dealing with. Now, as I understand it, we've then got a question: does that criminal conduct have to be after May the 20th, 2007, or can it be before that? That's one issue with relation to the exceptional rule of legal professional privilege. And it's not clear to me at the moment whether you are accepting that evidence of criminal conduct prior to May the 30th, 2007 is the primary way in which you're seeking to get legal professional privilege in. But there is the secondary issue that I think you may be putting forward, that you are accepting we're only concerned with criminal behaviour after May the 30th, 2007, but you're seeking to use material from before that date as explanatory material in relation to crimes committed after May the 30th, 2007. So my question is, I'm not quite sure which of those submissions you're making.
My Lord, can I begin by saying that I won't allow my submissions to drift from or even tempt to suggest that the Proceeds of Crime Act can be used to prosecute anybody for any offending before the 30th of May 2007. I accept that. I think
it could be charged under other legislation.
Under the Proceeds of Crime Act, they could have been charged with money laundering under the Money Laundering Act. And therefore, your Lordship's, I think your Lordship's point is that if it wasn't an offence under the Proceeds of Crime Act, therefore legal professional privilege must step in and stop access to that material because the law says it wasn't a criminal act before the 30th of May 2007. But that we would submit lies at the heart of the Swedish case to which I've just referred, because the law says in Sweden that it was not criminal before the 30th of May because of the Limitation Act, but that you can rely on that evidence. You can't prosecute it, therefore it can't be criminal. In the facts and circumstances of this, I am aided by the Money Laundering Act, where that material could be used to put forward the argument, if we're right and it exists, that there actually was unlawful conduct. There was conduct that offended legislation that was in existence at the time.
So is that your primary submission about legal professional privilege?
No, my primary submission about legal professional privilege has to start from the position that a conveyancing file doesn't really attract legal professional privilege. It's neither advice nor litigation protection. So that the principal documents in a conveyancing file, it would be very difficult to see how legal professional privilege would bite on anything that proved the dates of transactions, who the parties to the transactions were, where the money was coming from, and how the money was utilised. If there are documents in there, and that would be subject to this yet to take place sift, that showed advice being tendered by the attorney or requests being made by by Andrew Hamilton or one of his members of his family, the issue of legal professional privilege might arise, but of course it would be trumped by, and I'll use the phrase again, the eye-watering evidence of the appellant in her affidavit, which has not been answered, relating to the conduct of the attorney.
Well, can I just contextualise that to an imaginary document? I know we haven't got them, they're all sealed. Suppose the judge doing this sift, I think it's going to be done by a judge, comes across a pre-POCA conveyancing document containing legal advice, which wasn't advice about a transaction which was only going to take place after POCA came into force, but about an earlier transaction. And you say it's relevant to show that there was already this relationship of money laundering between the parties before POCA came into force. Lord. Therefore, it's relevant to your post-POCA date prosecution. I think you're saying, but nonetheless, you can overcome the privilege that would ordinarily attach to that record of the giving of legal advice about an earlier transaction, because there's no confidence in iniquity, even though the relevant iniquity was a money laundering iniquity and not a POCA iniquity.
Precisely. It doesn't exactly, and it doesn't therefore matter that it was
providing that it is, as it were, within the confines of no confidence in iniquity.
Absolutely.
Yeah.
Yes. It's the no confidence in iniquity.
Whereas if it was legal advice about a transaction which, as far as the judge could see, wasn't in the least bit unlawful,
Well, then
the privilege would attach.
well, privilege would attach, but there'd be no
You say it
benefit.
probably wasn't relevant, but the judge wouldn't want to conduct the relevance analysis himself. All he's doing is conducting the privilege analysis, as I understand it.
I agree, and whoever the judge was that conducted that analysis would have necessarily to have an understanding of what the case was about, and would be making
But he
that
would be
judgment.
usurping the trial judge's function if he conducts a relevance analysis.
I agree.
But not if he conducts a privilege analysis.
I agree. And so I hope...
Could you take it even further? Does it really matter at all what the criminal conduct was that falls within the criminal exception? Does it have to be anything to do with money laundering?
No, it could be, and in this case, when you read the eye-watering affidavit, there's evidence of fraud, there's evidence of forgery, there's evidence of creation of false names and so forth. So I agree with that. Yes, Lord.
And I'd understood you to be saying that really this is all ongoing criminal conspiracy, so it really doesn't matter whether the test is criminal conduct or understanding the background. It falls within criminal conduct.
Yes, Lord.
And
yes, the difficulty I have to address is the submissions advanced by my learned friends, which is, of course, that if it wasn't criminal before the 30th of May, I mean, that's their point. And I answer that not only on the basis, well, actually, that eye-watering affidavit has got evidence of unlawful criminal conduct before the 30th of May starkly revealed within it, but also it's not accepted that to be admissible, which I think is their argument, it has to be criminal conduct in order to be able to advance that evidence before the court, and therefore it becomes feasible on their argument because it wasn't criminal conduct before the 30th of May. I mean, our submission would be that it's relevant. What is relevant evidence? What is capable of being used by the Crown in support of its case? Now, I think that I can identify, with all due respect to my learned friend Mr. Williams, the fallacy in his submissions, because he rests a lot of his argument on what he calls immediately admissible or immediately relevant. And he has fallen in, we respectfully submit, into this error, because he has, for the main part, in order to sustain that submission, relied on a case involving the BBC and Newcastle Crown Court, which your lordships will find at 998. And doing the best I can, and without making any statutory references, save and except I need to, the background is as follows. A defendant was charged with historical sexual abuse. And in respect of one person, one alleged victim, the BBC had interviewed him, and there'd been a mock interview, no recording, but she'd made some notes. And the Crown applied for access to what may be described special material, special procedure material, and the judge had granted the production order. To cut a long story short, Lord Justice Leggett, sitting with Mr. Justice Picken, set that production order aside. In fact, the document had been produced, in fact, it had been utilised at the trial, and in fact, the defendant had been acquitted, interestingly, of that charge, albeit he was convicted of others and sentenced to a fairly long term. But my learned friend relies on this for his immediately admissible without more point. But the problem that he faces is that the statutory scheme in England and Wales is that the judge has to decide on such a production order is likely to be relevant evidence. And that is so far removed from where we are in a search and seizure warrant when the officer is, in the early days of an investigation, looking for investigative material, which by definition could never pass the is likely to be relevant evidence test, because the officer is looking for that material for the purposes of an investigation. And indeed, from the BBC case, so therefore I am very grateful to my learned friend for it, we can see this set out. First of all, please, at paragraph 13, page 1003, that sets out the important parts of the Police and Criminal Evidence Act. Section 8.1 of that Act empowers a Justice of the Peace on an application made by a constable to issue a warrant authorising the police to enter and search premises and seize material found on the premises if satisfied that there are reasonable grounds for believing A, that an indictable offence has been committed, B, that there's material on the premises which is likely to be of substantial value, whether by itself or together with other material, to the investigation of the offence. And that is almost word for word the Jamaican scheme.
I'm so sorry, can you remind me the page number?
Of course, Neil, 1003.
1003, thank you.
Was it that cleaned a big, big carpet for less than half a crown? No, it was something.
That was 1001.
I think it was. It was 1001. Thank you. And at sea, my lord, so having interrupted myself with a light-hearted moment, I then lose the thrust of what is really important. At paragraph C, that the material is likely to be relevant evidence. And so the BBC case doesn't help my learned friend, because, of course, it therefore would qualify immediately admissible. But that isn't the test under the Jamaican legislation, which I will take you to in a moment, that it does not consist of or include items subject to legal privilege, excluded material, special procedure material. And then this, we submit important, because it defines criminal investigation, and I can only put it forward as a helpful suggestion, because search as we may, and boy do I have some experience behind me, or sitting next to me, there is no definition of criminal investigation. But I was going to submit to your lordships that criminal investigation is an investigation into whether or not somebody has committed a breach of the criminal law. But we see at paragraph 22 the phrase criminal investigation, whilst not described in PACE, it is described in the UK's Criminal Procedure and Investigations Act. A criminal investigation is an investigation conducted by police officers with a view to it being ascertained whether a person should be charged with an offence. And that, Lords, you'll find at page 1005. So what is our takeaway from this important case that Mr. Williams for the First Respondent relies on? Well, we get some help as to how we may address the issue of investigation. Perhaps mine, whether or not somebody should be charged or whether or not somebody has committed an offence, assisted by paragraph 22 as to the statutory definition in England and Wales as to what an investigation is, together with the test that he claims of immediately admissible is dependent on the statutory language in England and Wales, that it has to provide for relevant evidence, which the Jamaican scheme does not. So can I, in that context, take us, please, to the relevant part of the Jamaican scheme? And for that, my lords, we would need to go, please, to I'm sorry, I'm scrolling to find it, beginning at page 688, my lord. And can I say that in turning to this and beginning at section 115 of the Proceeds of Crime Act in force in Jamaica on the 30th of May 2007, just emphasize that we are not, as far as we're concerned, in this appeal, although it's raised by one of the respondents, addressing the access conditions. That's been litigated out, and we respectfully submit that it's inappropriate, indeed wrong, for learned friends to try to raise that here before you. It's not an issue before the board. The issue before the board, and I repeat, is whether affected or not by legal professional privilege in the small way which we have dealt with it, material predating the 30th of May 2007, relevance and therefore appropriateness for the judge in issuing a search and seizure warrant to permit the officers to take that material away. And I've dealt with that argument. But just looking at the search and seizure warrant, section 115(1) at 688, a judge may, on an application made to him by appropriate officer, issue a search and seizure warrant if he is satisfied. And learned friend picks up on disclosure orders and those issues, and we submit we're not going to deal with it, but it's there on the affidavit as to why a disclosure order is not going to work. Picking up at a money laundering investigation at the top of 689. The warrant is sought for the purposes of the investigation. The warrant is sought in relation to the premises specified, and the warrant is sought in relation to information or material specified in the application, or there are reasonable grounds for believing that there is information or material falling within 116(6) on the premises. And then it defines what a search and seizure warrant is, and in particular, 3B, to seize and retain information or material found which is likely to be of substantial value, whether or not by itself, to the investigation for the purposes of which the application is made. And we would submit that not every investigation ends up with a prosecution, but it's important for an officer to be able to investigate in order to seek advice from the Director of Public Prosecutions as to the efficacy of a prosecution. But over and beyond that, if I'm having to go down a relevancy to any subsequent prosecution route, well, I've already argued that, and respectfully submit we have more than amply established that the material is so entwined and connected with what happened on or after the 30th of May as to make it relevant, of substantial value, and necessary for the proper presentation of a case, and that, with all due respect to the reasoning of the Court of Appeal, it cannot be defeated by the ruling that even if the evidence is incomprehensible without it, that has to be flawed. It can't, with all due respect, stand the test of what is properly allowed to be investigated to go before a court. Lord, the section moves on, page 690. The subsection applies if there are reasonable grounds, subsection 2, for believing that in the case C, in the case of money laundering investigation, the person specified in the application for the warrant has committed a money laundering offence. it would not be appropriate to make a disclosure order. The affidavit explains why that plainly is the case. And there are reasonable grounds for believing that any information or material on the premises specified in the application of the warrant is likely to be of substantial value. The phraseology with which the court is familiar, and it's in the public interest for the information to be obtained, having regard to the benefit likely accrue to the investigation if the information or material is obtained. There is nothing in the section which deals with or can be closely described as being connected with the legislation in England and Wales which speaks of it being relevant evidence. And then Lord 692, subsection C of subsection 6. In the case of money laundering investigation, the information material relates to the person specified in the application or to the question whether that person has committed a money laundering offence and is likely to be of substantial value, whether or not by itself, to the investigation for the purposes for which it is sought. Then section 117, which we submit, of course, is relevant, not only for your lordships to note, but to learned friend submissions. A search and seizure warrant does not confer the right to seize any information or material that a person would be able to refuse to produce on the grounds of legal professional privilege in proceedings before the Supreme Court. We would recognise not only is that provision plain on its face, but it would be right whether it was there or not. But that the evidence supports the State Crown's case, that there is a clear exception to that claim. So that deals with Mr. Williams's hook of the BBC case. What that case is about, which is not related to the Jamaican legislation, and therefore doesn't, we submit, assist the board in determining what approach should be taken by the court to material before the 30th of May 2007. Lords, there is a lot in the respective cases about what material outside the four corners of a criminal allegation may amount to be admissible. And it's plain that the principle, the modern principle, would appear to be that if the material contributes to the court's understanding in a way that explains and informs the court of the events that are being tried, then that material is relevant and admissible and becomes more probative than prejudicial. But as I address those words, it is plain and clear that that is an issue of judicial determination during the course of a trial. It is not, we submit, a cause for judicial determination at the time when a search warrant is being sought. The search warrant has to pass the test of whether or not a person has committed a money laundering offence and whether or not the information or material is likely to be of substantial value, whether or not by itself, to the investigation. And we would submit, and I keep resisting going to it, and I don't know whether, as my time is still some way to go, I should resist the temptation anymore. But that affidavit really does tell the tale. I would submit that the reading of that affidavit is not, for me, in submissions before you, but is simply, I highlighted some of the paragraphs, something which the board will want to consider.
You can take it the board will read the affidavit.
Thank you. It's not a sensible use of my lord's time. What is clear is that the Court of Appeal took the view, and we submit they misdirected themselves, that if it existed before the 30th of May, it was like it didn't exist at all, because it could only be relevant if it existed on or after the 30th of May. And we submit that that is a misapplication of the principles which are rehearsed by the court in their judgment and rehearsed by us in our written submissions. And that the Court of Appeal, in addressing the issue of criminal conduct, which it does between electronic bundle pages 245 and 275, were focused and misdirecting themselves on that commencement date. So that if I turn now to a few more of the authorities, but not in any great detail, we are the subject of criticism by the respondents that we only refer to Lord Hughes's decision in ARA, the Asset Recovery Agency, Jamaica, beginning at electronic bundle 694, in passing. Well, it only has one relevant part to it, which is the part that we referred to, and that is that the Act, remember please the Swedish case, the law can only be used as effective on or after the 30th of May, and that's the decision so far as it's relevant to this case. I think described as seminal by one of my learned friends, I might say plain and obvious. But that doesn't affect, nor is the case authority for the proposition in relation to search and seizure warrants and money laundering investigations. And we submit that the only takeaway is what is not in dispute between us, and that is you can't prosecute anybody for criminal activity before the 30th of May 2007 under the Proceeds of Crime Act. Mr. Williams raises in his case between paragraphs 19 and 21, which is at page 426 of the bundle, the issue of land transfer dates and how he suggests now that there has been some misleading of the court. I am delighted to say that I am not going to get involved in land transfer dates or their impact on the Registration of Titles Act, because my learned junior, Mrs. Hay, Queen's Counsel, is going to deal with that before we close our submissions. To the extent that that is, I think, a hook of criticism now made for the first time, that there was some suggestion that the learned judge who granted the search and seizure warrant was misled. In the case of Foggo, the Asset Recovery Agency in Fogo, electronic bundle, page 367. The suggestion is, in that case, that you cannot inquire into pre-poker activity. In our respectful submission, it doesn't deal with that. It deals with offending. It doesn't deal with evidence. And indeed, what is the criticism, you may think, of us by that? Forgive me. Forgive me. Did I just take them to the... I'm sorry, Lord, I think I misreferenced it. I think I took you to the case, not to the submission, not to the case.
Yes, you did.
Give us the submission. I'm sorry.
hoping you'll give us the page
The case is at 708. That's entirely my fault.
Where is the case?
708.
708. Thank you.
Forgive me. In Williams, Lord, and I've not made it. Oh, I know where I can find that because I've written these all down. Williams is at page 732. The first respondent relies on this case to support the argument that the judge doesn't mention the access requirements. Lord, again, this is, and it becomes a little difficult because in the respondent submissions, they're raising points which we haven't hitherto had to deal with. But we would respectfully submit that once you've read that affidavit and your lordships see what it is that the judge did in granting the search and seizure warrant, and then read Mrs. Justice Straw's judgment on how the court is to resolve access to the still sealed material, your lordships may conclude that the access conditions were more than amply justified, and that the failure, if there is one, to set out in a judgment, of which there isn't one, of the judge who granted the search and seizure warrant is of little relevance. And indeed, Lord, in one of the cases that we look at, give me just a moment and I will find it. Would your lordship forgive me the one where... I think your lordships may get some help on this narrow point from Electronic Bundle 941, the Crown Energy Finance Team Limited against Bow Street.
The page number again, please.
And that's 941, Lords. And your lordships will find what we take away from that is the warrant drawn widely will not simply be fishing if it's directed to support an investigation which has apparent merit. And therefore, reasons, and this is the difficulty we have in responding to this part of my learned friends' submissions, and it may be that I'm better to wait until they've addressed them orally, but they have put it in writing. The difficulty that we have is that the issue of reasons is not something anybody else has been asked in the litigation line that leads to the matter being brought before the board to date. And therefore it's difficult to deal with it, save and except to say that the reading of the application, which remains unanswered in the context of this branch of the litigation, or at all, and then the judge's search and seizure warrant are clear on the face of it and cannot be subject to any suggestion that it should be impugned because there's no note of the judge's reasons. And so similarly, electronic bundle 955, the reference to Mills and another and Sussex police, where the court holds that there can't be a search and seizure warrant if there's not been full and frank disclosure. Applying this test, if the warrant granted could be refused if the information withheld would have been before the court, then the warrant would be quashed. And the problem is that we don't know what it is that's suggested that we haven't fully and frankly disclosed. And nobody has sought to come to terms with, nor mentions, and we would submit it's hardly surprising, what it is that the appellant had set out before the judge in such detail at the time.
But these are new legal challenges which were not pursued in the courts below.
Yes.
And the board has an established practice in that regard.
Yes, Lord. And that's why I'm dancing round it, because
yes,
they form such an essential part of the learned friend's case. But I'm taking that guidance. I think I'm going to stop dancing round it and just not engage.
Thank you.
Lord, what I also won't engage, if your lordships will permit me, in any consideration of the authorities around striking similarities in the evidence, the consideration of prejudice outweighing probative value, because all of those issues we submitted are trial judge issues, and I'm drawing back from all of that simply to say that if one reads the affidavit and asks oneself the question, is that material upon which a court, in considering whether or not to grant a search and seizure warrant, could be satisfied that there is information or material that a person named in the application has committed a money laundering offence, and that it's likely to be of substantial value, whether on its own or together with other material to the investigation, and I will add, it's in the public interest. And Lord, we submit that we are more than home on that test. And so I'm not going to deal with those striking similarity cases, nor, Lord, in the light of what my Lord President has said, am I going to deal with the constitutional point, which is Mr. Williams suggesting, well, you can deal with the constitutional issue now because of Solomon and Mallin in the Caribbean Court of Justice, even though it hasn't been raised below. I say that because it was raised below, and the court gave it short change because it wasn't properly articulated or argued before them. And your lordships will find that in the Court of Appeals judgment. I think it's paragraph 115. Somebody will very quickly give me the page reference to that. And so, Lord, I respectfully submit that so far as the substantive part of our appeal is concerned, I have covered all the issues. The court may think it's page 289 of the electronic bundle where the court deals with the constitutional point. I have dealt with the substantive issues and the relevance and the cases which we refer to in our written case, beginning with Petman. And I'm embarrassed, because Petman is so old, to remind myself that I appeared in it being led by the late Alan Rawley. Goodness, 1985. I thought I was still at school, but plainly not. Plainly not. I take away from all those cases that, first of all, the issue of relevance and admissibility is a matter for the trial judge. Secondly, the test of substantial value to an investigation of the material is an entirely different creature to the test of substantial value or relevance or admissibility in a trial. And an investigation, of course, is an opportunity for the investigator to have as complete an understanding of the issues that the investigator needs in order to seek advice as to whether or not to bring proceedings. And the question of relevance and admissibility is a matter not, therefore, we submit for the judge granting the search and seizure warrant, but for the trial judge. And so as helpful as those cases are to the principle of what may or may not become relevant, and we set them out beginning in the core printed bundle at page 189, page 6 of ours, and the electronic bundle page I'll be given in a moment. We set out these cases in order to establish the principle that there is no bar to the admission of the background history if it is relevant to the offences charged in the indictment or in the charges that are in this case, and that therefore those legal principles are well established in our submissions between paragraphs 24 and 29. But we probably, in dealing with that, took and went further than we need to, because in order to get over the hurdle of public interest, relevance to whether or not somebody has committed an offence, and its substantial value by itself or taken together with other material to the investigation for which the warrant is sought, it is plain as a pikestaff we would submit that if you have a long and detailed relationship between a convicted drug trafficker, Mr. Wilkinson will note, as evidenced in the affidavit of the appellant, and an attorney, with the use of family of the drug trafficker and the relationship between that attorney and the family of the drug trafficker in, for instance, joint accounts, that is more than likely to be of substantial value, whether by itself or to the investigation.
I was wondering, Mr. Mitchell, if you could help me. We have you've identified where the warrants can be found.
Yes.
Do we have in the papers the actual charges, the indictment?
No.
Yeah.
They're all, I can help you. May I just say that the cases from our case, which we summarise, are between 408 and 411 in the electronic bundle. You don't have the charges. What you do have in the affidavit of the appellant for the warrant is her setting out the criminal conduct which she is investigating, the types of offences that she's investigating. But the charges have not found their way into the litigation, this branch of the litigation. I should say, and I was going to at the beginning of my submissions, just very shortly, that litigation continues in the parish court as summary offending, and it is adjourned until September. It's been going on for a very, very long time, but in bits and pieces. Mr. Wilkinson and I are used to criminal cases which go on a very, very long time. And this one continues. There is an application by the respondents to stay because of the length of the trial, the defendants in the criminal trial, but the judgment on that has been adjourned until September, combination of judicial availability and counsel's availability. The Crown State's case continues, it hasn't closed. If my lord wishes to have those specific charges, I'm quite sure we can obtain them, subject to learned friends having any objection to it, and email them to the court.
Thank you.
I think Mr. Wilkinson objects. He does. Okay, but then we won't send them without consent. All right. Can I assist your lordships any further? I'm going to pass otherwise to Mrs. Hay to deal with that.
Thank you very much.
Thank you.
Mrs. Hayes. Mrs. Hay.
May it please you, my lords. I rise to deal with a very discrete aspect of the submissions filed by the first respondent, to be found at your lordship's electronic bundle at page 425, paragraphs 19, in the first instance to 21, but I believe it is important to address also paragraph 25. And that aspect of the submissions made by the first respondent, my lords, complains of material non-disclosure and almost a direct accusation of misleading, whom I will call respectfully the warrant judge, on the question as to the relevant dates of the properties identified as relevant to the investigation in December 2013, which is the date the warrant was applied for. And the summary in 19, starts off by, in my respectful view, narrowing or attempting to narrow the scope of the investigation by identifying only the issue in relation to property. And I think it useful, if you permit me, my lords, since there has been some indication that the affidavit will be reviewed, to just say at the outset that the supporting affidavit of the investigator, the appellant, Ms. Smalling, addressed not only questions of property, but set out the scope of the money laundering investigation as it was known at the time, to include allegations of cash smuggling, allegations of cash management, allegations of importation of large value items such as heavy-duty construction equipment, conveyances such as fishing vessels, motor vehicles, and of course, broadly, different ways of handling cash. If you permit me, my lords, this is important to our case because of the allegation that there was not full disclosure in the without notice application to the warrant judge. And if you permit me to start by reference to page 156 of the appellant's affidavit in support of the warrant, in paragraph 13, she's careful to disclose at the outset that she understands her obligation to give full disclosure to the court, and sets out the background allegations in the matter to the extent she was able at the time. In respect of the references to the different types of offending, your lordships will find those between pages 159 and 168, and because of the promise to read, I will not detain you unless you wish me to take you through it. In relation to the real estate, which includes two tables which feature in these respondent submissions, between pages 159 to 168, at page 168, paragraph 34, there's the allegation that treats with the movement of raw cash and an attempt to introduce a sum of about 200,000 United States dollars into a bank account. At page 170, paragraph 39, there's the reference to the heavy-duty equipment acquisitions, the fishing vessel, the motor vehicle, or vehicles plural. At pages 174 to 176, paragraphs 47 to 53, there are the allegations of cash smuggling. And your lordships will see some analysis in those allegations which mirror travel patterns of, at the time, the second respondent, who is now deceased, is Anne-Marie Cleary, second respondent in the criminal proceedings, sorry, not in today's proceedings. At paragraph 52, some mapping of the dates of landing, arrivals in Jamaica, and accretions or injections into an account that is jointly held on the investigation in the names of the first respondent and a deceased daughter of Mr. Hamilton. And so the pattern was explaining the theory at the time of cash smuggling.
Mrs. Hayes, was this argument raised in the courts below that there had been non-disclosure?
My lord, I would have to say no. The arguments in the court below were faithful to the grounds of appeal. I did take the hint, strongly made, in relation to the approach of the tribunal on matters that I raised new. I rose after conferring with Queen's Counsel Mitchell because the point of importance for us was a suggestion that we misled the warrant judge. I can certainly summarize my concern very shortly in relation to the submission, if the court wishes to hear from me on that.
Well, we are prepared to hear from you, but there is a preliminary point whether it is appropriate that we deal with this point at all if it wasn't raised in the courts below. But if you are concerned about the reputation of the organisation which you represent, I'm not going to stop you speaking, but I should indicate to the respondents that the court is likely to stick with its current practice of not considering legal challenges raised here for the first time.
Well, my lords, I believe that to the extent that I am concerned with my client's reputation, I've expressed it. I've also left in your lordship's hands the aspects of the affidavit which demonstrated the scope. And certainly I can take my seat by saying that although the affidavit was filed in 2013, to date, there has been no assertion anywhere in the extensive litigation that has taken place in this matter that any of its content was incorrect. And there's certainly been no challenge proffered by any party offering contrary evidence. My lords, the urgings I'm getting from my leader suggest that I should clarify one thing, and that arises in paragraphs 21 and 22 of the first respondent submissions. And that is at the page 425. And the core of it, as raised, is that there are different dates or multiple acquisition dates, potential multiple dates, relevant to property acquisition in property transactions. And that at the time of the application for the warrant, the only date that was referenced was the date on the titles. We did send this morning, at the invitation of the registrar or clerk, a copy of our Registration of Titles Act. And we will rely on Section 88 of that Act, which sets out the time when a transfer is effective of property. It is the date the transfer is endorsed on the title. What was put before the warrant judge in tables 1 and 2 are those dates. Considering that this is being raised for the first time, I'm guided that I don't, unless your lordships have questions, need to take it further. But we do mention that to indicate there has been no belated admission of any information. Everything on which we rely now, we relied on in 2013 and has not been challenged, unless I can assist you further.
Thank you very much.
It's a pleasure, Mr. Chair.
Mr. Williams.
Thank you. I would begin, my lords, by referring to my written case and noting that at paragraph 4, I have summarized my argument into 3 propositions. I would also crave to make a little correction at the first of my propositions to say that it means immediate admissibility, not immediate relevance. At the end, say to the immediate admissibility. And I would go directly to that point without any long run-up, which is covered at beginning at part 8 of the submission. My learned friend, Mr. Mitchell of Queen's Counsel, seeks to answer this point by saying, as I understand it, that relevance is not a statutory requirement under the Jamaican regime. I may say with respect, I'm startled by the argument because my learned friend's submissions are in fact that the background evidence ought to have been admitted because it is relevant to the offences charged. And he says the public interest requirement is also, relevance is also a plain component of the public interest requirement. I cannot see how it is that a judge or granting a warrant cannot consider relevance. The question is relevance to what? And if I take you to page 689 of the electronic bundle, your lordships might see section 1152B of Jamaica's POCA, which makes the point that one access requirement is that the warrant is sought for the purposes of the investigation. And it is my submission that it is plain that the warrant must be relevant to the investigation. It is plain, and I would ask your lordships to consider the 3 authorities which I have referred to at paragraph 8. First, a decision of Lord Bingham in Crown Court Ex parte Hill, and then the important Derby Magistrates case, which I would want to take you to page 1028, to make the point that in England, where this has been much more litigated than in Jamaica, the access condition for a search warrant has always been relevance, but the point being relevance not equating trial relevance with investigating relevance. In other words, trial relevance doesn't ipso facto mean it is investigation relevant. And that trial relevance, investigative relevance has always been, would it be immediately admissible at the trial without more? That is the question. This short point that I'm making is, I could say, could be a decisive point on this appeal, because clearly background evidence is not, it's never immediately admissible. Indeed, it is immediately inadmissible. So if I'm right on this point, I think it would clearly defeat my learned friend's submission. Could I take you to page 1028 of the electronic bundle? And this is the case of the Derby case, the House of Lords decision. And I think they're considering, is it Pace? That they're not Pace, it's a Criminal Justice Act. And at letter D, their lordships say, in my judgment, those observations are correct. Both the stipendiary and the divisional court in the present case were impressed by the arguments deriving from the more stringent duty of disclosure now placed upon the prosecution. So therefore, the item was a matter which was certainly of substantial value. They also considered whether the documents sought were material in the sense of being generally useful or helpful to the defense, rather than whether they were likely to be of material evidence within the meaning of Section 97. In my judgment, for the reasons set out above, the summonses ought not to have been granted under Section 97. So looking at the question of material evidence to the investigation, the Derby Magistrates Court decision is indicative that substantial value, admissibility of trial, doesn't ipso facto mean relevance to the investigation. The BBC case, a decision of Lord Justice.
The test there is it to Section 97 is at page 1024.
1024.
It had to be likely to be material evidence in the proceedings, didn't it?
Yes.
So it wasn't, first of all...
Well, that was a witness summons in
in
the case. It was a witness summons in that case.
Yeah.
Which the BBC, the Derby case is the beginnings of the principle, which thereafter have been applied to pre-trial issues. The point I'm making is that it is, apart from a statute saying relevant, statute saying likely to be material, it has been applied in the same way as consistently since then.
Well, in the BBC case, they treated likely to be relevant evidence as the same as likely to be material evidence,
yes.
i.e. relating it to the proceedings.
Likely to
That's
be relevant,
why there's admissibility required.
But likely relevant to the stage of the proceedings that you're at.
Well, an investigation isn't a stage of proceedings at all, is it?
Well, indeed. And the BBC case, it was indeed at an investigative stage. That BBC case, let me again find that page number. BBC case is at page 998. It was an investigative stage, although by the time it came for argument, the investigation had long passed, and the arguments were now being purely on academic issues for future learning. And the court was seeking to determine how the access conditions for production orders and the test for relevance for production orders ought to be applicable. What does it mean? And the Derby case was sought to be distinguished, which is much of what Lord Justice Legat says is the question as to what is the status of the Derby case in these conditions and at this time, because this is a 2020 decision. So if your lordships look at page 999 of the electronic bundle, which is page 275 of the case, the second holding makes the point that likely to be relevant evidence meant that it would be immediately admissible in evidence at a trial without more. So at the investigative stage, the question is it immediately admissible in evidence at a trial without more? If your lordships look further down, the head note says, having regard to the definition of relevant evidence, in Section 97 of the Magistrates Court Act, citation language, Schedule 1 of PACE had to be interpreted as meaning that there was no requirement for the judge to further assess the likelihood that the material evidence once produced might subsequently become admissible at trial if some further event occurred or some further procedure followed. As well as being an unnatural reading of the words, which is a pure interpretation question, the second part I rely on, such a test would potentially give rise to real difficulties in application. It would not reasonable to impute to Parliament the intention that in order to determine whether the material sought was likely to be relevant evidence, decision maker had to engage in a potentially complex and uncertain exercise of trying to predict and analyze whether the material which would not be immediately admissible evidence might nevertheless become so as a result of how evidence would unfold in the course of a future criminal trial. It followed that the judge had been in error. So the point that I think that Lord Justice Legat, as he then was making here is, a judge at the stage of granting the production order, and we say search warrant, should not be put in the complex position to go beyond what would be directly admissible at trial to be determining what may be admissible if certain things happen or if certain conditions are made out. And I would, it is quite clear in the judgment. I would take you to the analysis, which begins at electronic 1008. So, which is paragraph 34. And your lordship can see, I will not read it, but your lordship can see that at paragraph 37, the Derby magistrate's case is dealt with.
So you see paragraph 34,
34, my lord, yes.
Says the phrase relevant evidence is defined to mean anything that would be admissible in evidence at a trial of the offence.
Indeed.
There's nothing equivalent to that in section 117.
But my point is,
118.
The scope of issuing a search warrant must include a determination of what is relevant under the search warrant, and whatever the statutory language may be. My learned friend has tacitly admitted that, because his argument is that the background evidence would be relevant at trial. The statutory condition is it must relate to the money laundering investigation under POCA. So for it to, which is 1152B in the statute. Now I admit it's not the same language, but how can it be that a search warrant could lawfully permit irrelevant material to be produced? That certainly would not satisfy the public interest requirement, because what we're here looking at with a search warrant is a severe imposition into the right to privacy, and it must have defined limitations. So the search warrant procedure must be seeking material relevant to the investigation. And the question is, all right, what is relevant to the, this is where I think we part company. What is relevant to the myself and my other friend, what is relevant to the investigation? Is it what may be relevant at trial, or what must be relevant at trial? Or to put it in the words of Lord Justice Legat, what is immediately relevant at trial, or what may become relevant at trial? Let me make it very practical in this case. Background evidence requires a trial judge to consider prejudicial effect and probative value. It requires the trial judge to consider whether the evidence will be incomprehensible without it. A very high standard, incomprehensible without it. These are considerations which are not appropriate for a judge at a warrant stage, which is what Lord Justice Legat says between electronic 1008 to 1012. Lord Justice Legat makes the point that at the search warrant stage, the relevance question should be simply answered, the principles should be simply applied, and avoid complex issues. And background evidence brings with it a complexity which is not for this stage. Let me continue to take you to that, because I was at 1008. Paragraph 38. The Lord Justice Legat at that paragraph reviews the Darby case and approves for a different statutory language, the argument that it must be immediately admissible per se and without more. Your Lordship will see that, I think, 8 lines down of paragraph 38. At paragraph 42, he deals with the question of statutory interpretation, which I will pass for now and take your Lordships to paragraph 47. Where Lord Justice Legat says that the access conditions should be similar to those under a witness summons, should be no different, and was seeking to have a consolidated approach to this question. Paragraph 52, which I would rely on my lords. We conclude that the Derby Magistrate's case remains good law, which is binding authority for the proposition that a person cannot be ordered to produce material unless it is likely that the material, if produced, will be immediately admissible in evidence without more. It's not enough that the material will become admissible if particular events happen at the trial. This is the important part. This is how the balance has been struck by Parliament between the public interest in the effective investigation and prosecution of crime, which would by itself favor disclosure of any material likely to be of substantial value to the investigation, and the right of the citizen to privacy and freedom from interference with their property, for which this further access condition affords a significant protection. So I rely on those principles. I would also, to conclude on the legal part of this, take your Lordships to page 1065 of the electronic, which is Ex parte Hill. And this decision, I believe it's of Lord Justice Bingham as he then was, is considering how it is that we make this balance between public interest requirements and
65.
And the requirements for effective investigation. And I could take you to page 1071. I don't think these paragraphs are numbered. Page 1071, where Lord Bingham is quoting from Lord Widgery in Williams and Summerfield. I hope your Lordships are with me. Page 1071 in the electronic. And there is Williams and Summerfield, and the third paragraph of that quotation. I think that in criminal proceedings, justices should warn themselves of the importance of the step which they're taking in making an order. Should always recognize the care in which a jurisdiction should be exercised. Should take into account, among other things, whether there is other evidence in the possession of the prosecution to support the charge, or whether the application of Section 7 is a fishing expedition in the hope of finding some material upon which the charge can be hung. I pause. If there is not a relevance requirement, it would mean that the Jamaican provision for search warrants would be one which would be of a nature of fishing expedition. If the justice approaches these applications with a due sense of responsibility and a recognition of the importance of that which they are being asked to do, if they are always alive to it, the requirement of not making the order extend beyond the true purposes of the charge before them, the true purposes, so it must not extend beyond what is material. And if in consequence they limit the period of a disclosure to the bank account to a period which is strictly relevant to the charge before them. So there is that time limitation. It must be the period which is strictly relevant to the charge before them. So I don't think I need to, I hope I'm not belaboring that point, but it must be that the search warrant must be firmly rooted in relevance. And the question is, relevance how, or what is the relevance? And the authorities make it clear that the relevance must be immediate admissibility at trial. Now, I think I don't think it is disputed that background evidence is not immediately admissible. I picked this up at paragraph 9 of my written submissions. I don't think that can be disputed. Background evidence is never immediately admissible. And I set out the authorities there, and I also have included, very briefly, from the Myers case, the warning of Lord Hughes regarding the Petman, applying Petman, and that it must truly be background evidence, it must truly be incomprehensible without it. Now, there's a practical point that I would want to make as regards this too, my lords. In the application for the search warrant, there is no mention of background evidence. It is not referred to. The impression given in the application for the warrant is that all of these materials are POCA offenses. So therefore, the learned judge in granting the warrant was not required to make any determination regarding background evidence. So what we have is, after the warrant is granted, the other side have enlarged what they want to get under the warrant. As Lord Justice Legat says in BBC, it's not appropriate for the warrant judge to be considering these complex issues. But if they wanted to get it, they needed to have put it before the warrant judge and let us see the warrant judge deliberating with these complex issues. And I shall soon show why they are even more complex in this case. I think I have exhausted my first brief point. And I think I would ask your lordships to dismiss my learned friend's argument that the Jamaican statute is somehow different in that there is no relevance requirement, because there must be a relevance requirement. My second argument has to do with the public interest. And as we see, the public interest weighs the public interest for investigation and prosecution of crime against the right to privacy, the constitutional right to privacy. I know my learned friends say that this was not dealt with by the Court of Appeal and so forth, and rightly so, and whether your lordship should deal with it. And perhaps I should spend a few minutes asking and imploring that your lordships do give it consideration for these reasons, which I have summarized in paragraph 6 of my written submissions. I'm going to show that the nature of the breaches are plain and patent by the agents of the Crown, and that the human rights considerations are central in the access condition of the public interest. So if you want to have access to material under a search warrant, you have to go over right to privacy hurdle. So one is not right to just dismiss out of hand right to privacy. But the other point is, this is the issue of the constitutionality was raised by the first respondent repeatedly. But the Court of Appeal inexplicably avoided consideration. And I would like to take your lordships to that because it is perhaps telling. It's at page 292, how the Court of Appeal treated with the constitutional argument. It's paragraph 118 of the Court of Appeal's judgment. If your lordships are there. Page 292, electronic 292, it's paragraph 180. The Court of Appeal simply say they would make no ruling at this time regarding the issues canvassed for breaches of the Constitution. And make, so there it is, and my client, the first respondent, brings this appeal, raises the constitutional issue, and the Court of Appeal simply says we're not going to deal with it at this time. And it's further egregious, my lords, because your lordships will note that the first respondent was appearing pro se before the Court of Appeal. Because by this time, the first respondent was unable to retain counsel because the state had restrained all her assets. There was an order which prevented her assets any exception to the restraint order for legal expenses. In Jamaica, there is no legal aid for money laundering offenses, no legal aid to come to the Privy Council. And so this was the first respondent without the aid of counsel, appearing before the Court of Appeal pro se, arguing a constitutional breach, and the Court of Appeal saying, we're not going to answer it at this time. Now, my learned friend, Mr. Mitchell of Queen's Counsel, made a slight error in his submission. It is true that there is a decision being awaited before the parish court to stay the proceedings, but it is not for the delay in the proceedings. In another judgment, the first respondent, again acting pro se, sought a declaration that the state must pay her legal expenses, and she was successful. But the state has continued to fail to pay her legal expenses, and she has taken an application at the parish court for the proceedings to be stayed because the state has not complied with the declaration. Now, there are arguments to and fro, and that is what the court is to decide. But that is the reason why those proceedings are currently in abeyance. We're awaiting that decision. So, those 5 points I make at paragraph 6 are the reasons why I asked the court to not, ask the board, not to turn your head away from this particular problem. Because this is a respondent who sought to raise it, raised it, did not get a determination. Now, at paragraph 7, I make the point that I was involved in DPP and Penn, and in that case, issues undetermined by the Court of Appeal was sent back to the Eastern Caribbean Court of Appeal. In Green Brown, issues that were undetermined by the court was dealt with by the board. So I think that your lordships would have either route, and I would urge that we consider it here because it is really central to the arguments that I would like to make. I would also ask the board to humbly bear in mind Rule 25 of the Judicial Committee rules, which says that a respondent can argue that the appeal be upheld on grounds different from those relied on the court below, just by putting that in their written case, putting those arguments in their written case. So that is the reason why I will make the following submissions. I'm at paragraph 12, which is making the point about the public interest test and what ought to be considered. And my concluding sentence of paragraph 12 is perhaps the important one. The run-up is that a search warrant is a fundamental breach of the right to privacy. This is a lawyer, this is your personal affairs and potential legal privilege. And also, the state had the option of seeking a disclosure order from the attorney, and so therefore had to show why they did not take that step rather than the step of you could call it the nuclear option of going by search warrant. I rely on the Asset Recovery Agency case for that principle at paragraph 21D, which is page 707 of an electronic note. 707.
707.
Yes, I'm sorry.
Thank you.
That's my first reference to asset recovery on paragraph 12. I also continue to rely on what Lord Bingham said in Ex parte Hill, which is at 1070 in the electronic bundle. That's this, your Lordship will see Ex parte Hill near the foot of paragraph 12. Now, it is settled law, it would seem, my lords, that there should be brief reasons given for the grant of a search warrant. And one would expect that there might very well be very simple cases where no reasons could be somewhat excused as causing no injustice. But it's certainly not a simple case. It's a complex case, legal professional privilege. In fact, a fundamental issue in this case is whether there is any investigation under POCA. That's a fundamental issue which I'll come to shortly. Is there an investigation under POCA? Another fundamental issue was, should they have gone by a disclosure order rather than by search warrant? So these are issues which are plain that require interpretation. I make the point that in the affidavit, there is no reference to background evidence. At the foot of paragraph 13, there are references to the record. I noticed that since it has been compiled, those references have slightly changed. So where in the penultimate line I mentioned record page 150, it's now at 156.
156.
Yep, my lord.
Thank you.
And where in the next line I mentioned 171, it's now at 177.
Thank you.
In paragraph 14 now, my lords, Agian and Williams is a very important case in Jamaica's jurisprudence from the Privy Council. It's at 737 in the electronic bundle. It makes the point that it is not enough for the person applying for the warrant to be convinced that the access conditions are met. It also must be that the judge or justice must himself be convinced. And so this is why reasons are important. But also, if one looks at the recital on the warrant, even the recital, does not contain all of the access conditions. So even the judge in granting the warrant did not traverse all the access conditions. And for that, I would ask your lordship to look at pages 29, 33, and 35, electronic on the record. 29, 33, 35, which evince that the recitals do not contain the acceptance of the accept condition.
So was that argument made in the courts below?
I would say not, my lord, but again, I would ask your lordship, as I did before, to recall, this was, my client is a conveyancing lawyer who was forced to make arguments before the Court of Appeal, unaided by counsel, her funds having been restrained by the state and not being provided any legal aid.
And what are the access conditions that aren't contained in the recitals?
But for example, there is no public interest recital. There is no recital that there is an investigation under POCA. No recital that the disclosure order would have not been appropriate. I think those are the ones. Indeed, I think the only ones, if I go back to my paragraph 14, I think the only thing mentioned, I'm sorry, could I crave indulgence? The only thing mentioned is that the material will assist the investigation. That is the only recital that I noted. Now, it's of course a settled principle that in an ex parte application there's a duty of candor.
Well, just wait a minute. If you look please at page 33.
33.
Yes. You say there's no recital of an investigation under POCA. But whereas it appears to me that the seizure of the above-mentioned articles will assist the MOCA in the investigation of the following offences currently under investigation in Jamaica, and then we have a reference to several sections, section 92 and 93 of POCA. So surely that is enough notice as to what's being looked at.
My lord, if we accept that, but certainly the other, there is no public interest, the public interest access condition is not mentioned.
Just take me to the public interest, the page number for the public interest access condition.
My lord, yes, it is, I have sought at paragraph 2 of my written submission to set out the access condition. Well, and public interest is 691 on the electronic. I think it's at the top of the page, 691, which is section 116(3)(b). Indeed, it is a...
Doesn't it stand to reason that if there is information or material to be obtained in relation to the offences recited in the warrant, that it would be in the public interest to obtain the material?
My lord, the public interest requirement was defined by the board in asset recovery to include a balance with the right to privacy.
Yes.
So it is not merely does it assist the investigation, but to balance that against the constitutional right to privacy, which is what Lord Hughes said in asset recovery. And that is a consistent application of that public interest test. The point that I make at paragraph 15 and 16 is the question of the duty of candor. Now, my learned friend says, oh, what are the breaches of this duty of candor? And I will set them out very plainly and very quickly. The issue of whether there was a proper POCA investigation is central. And this fell squarely on the question of what is the meaning of acquired, which my learned friend, Mrs. Hay of Queen's Counsel, started to deal with. And I set this out because when one is dealing with the Money Laundering Act and POCA in Jamaica, there is an important thing about the interrelation of the two acts. There is an assumption that if it's not an offense under POCA, it must be an offense under the Money Laundering Act, which is not correct, I would humbly suggest, for this reason. When Jamaica passed the POCA Act, it repealed the Money Laundering Act. So for a Money Laundering Act offense, let's begin. A money laundering offense is a predicate and a laundering. So it's the predicate, which is the predicate creating the criminal property, the criminal benefit, and then you do something with it. So it's a two-part offense. Both parts, I'm submitting, must take place under one regime or the other. Otherwise, there is no offense. So, the predicate offense under the Money Laundering Act the criminal property must have been created before 30th of May 2007. And it must have been laundered, that is acquired, concealed, whatever, before 30th of May 2007 to fall under the Money Laundering Act. If it is predicate before 30th of May 2007, dealt with after 30th of May 2007, there is no offense. So if the criminal property was created before POCA and it is transferred after POCA, it's no offense. For it to be an offense under POCA, the criminal property must be created under POCA and transferred, laundered, whatever, under POCA. So what was presented to the warrant judge was a case where everything was on that borderline, tiptoeing around that borderline of 30th of May 2007. Which is why date of acquisition in the table, it's in the affidavit and it's referred to here in the submission, is quite important. Now, Jamaica has a registered title system, a torrent system, where, if I could, I don't know if I need to explain it, but in a simple thing, you begin with an agreement of sale and proceeds pass, and then you have a transfer and all proceeds pass. And then the transfer is registered. And the date of registration is a matter for the registrar of titles. The purchaser acquires an interest in the property from the moment of the agreement of sale. So, that equitable interest is provided for in POCA, which I set out that it's provided for in POCA. So some of these conveyancing transactions can be quite delayed. Sometimes they are what I understand are called splinter titles, where one title is being broken up into many pieces, and it takes time for the Register of Titles to produce your title. But money has long since passed hands, or money has long since left the purchaser. So when the warrant judge sees date of acquisition, there need to have been a question asked. What did you mean by acquisition? Now, only now are we told that acquisition meant date registered on the title. Only in the SFI at these. This is something that the duty of candor ought to have required the other side to mention to the warrant judge.
Is there a specific provision in POCA saying that the date of acquisition is the date of the acquisition of the equitable interest?
Yes, my lord. I think I set that out. Let me find it for my lord. At paragraph 22, under POCA, property is held, obtained, and transferred by holding, acquiring, or transferring an interest in the property. Electronically, that's at 676.
Yes, I remember that now, thank you.
And an interest in land means a legal or equitable interest, that's at 677.
Yes, thank you. So section 2.
Right. So what we have then in this case is a situation where we cannot know whether, there is nothing presented to show whether any of these transactions fell properly within POCA. And certainly, if this was brought to the attention of the warrant judge, it would have caused her pause.
But how would the authority know, without acquiring the conveyancing file, when the equitable interest was acquired?
Well, many of these are available in public offices, like the stamp office. You can get the copy of the sale agreement. That's a public office. And you can see the copy of the transfer from the transfer office. You can also have got them from the lawyers on the other side. And Register of Titles, there are many places where one could have got these documents.
Thank you.
So at paragraph 23, I make the point that what in fact the appellant did was to procure the warrant by reporting the latest date without reference to the earliest date, the earlier dates. And that's a clear breach of the duty of candor.
So again, I'm sorry, I may have missed this, but again, was this an argument raised below?
Well, I will admit, my lord, as I have done that, and I again pray that the court will not turn away from it, remembering the how my client was forced to, as a conveyancing lawyer, to be arguing before the Court of Appeal issues of civil and criminal law, which and constitutional law, which was standing alone.
The second and third respondents were represented, were
by law, yes.
Yes. And could have had available this argument to them as well.
Indeed, I think I was not involved at those stages, I would say. I have only become involved in the last, I think, 2 years. And it's also important to know that the position that the first respondent was in, that a lawyer has a duty to protect their client's privilege. And she found herself in that position, and she had to do so before the court. So, could it be a convenient time, my lord?
Would this be an appropriate time?
It for me, my lord, it is. Yes.
Thank you very much. The board will adjourn and resume at 2 o'clock. Thank you.